Modern jurists and legal philosophers, they define law in a completely different way, and which we could say a complete departure of the definitions given by the legal philosophers of ancient Greeks and Romans. So, among them, Austin, the English legal philosopher and jurist, defined jurisprudence as philosophy of positive law. He made a systematic and scientific study of law as it is. When he is expressing it as scientific and systematic study of law, here he defined it as positive law, and that positive law is nothing but the command of a sovereign, and behind that command there is a sanction. So, Holland, another English legal philosopher and jurist, defined it as formal science of positive law. So, according to him, it is a positive law, but it includes only the formal objectives and concepts and excluded all informal ideas or ideals out of the systematic study of jurisprudence. And Salmond, another English jurist, defined it as science of the first principles of civil law or law of the land. So all those laws prevailing as it is in a state or society, such laws are civil laws, and such civil laws constitutes as jurisprudence. And Professor Allen defined jurisprudence as a scientific synthesis of essential principles of law. Only those essential rules or principles which are part of law, that is the study or investigation of jurisprudence. And Professor Keeton described it as scientific study of the general principles of law. So he included all those rules and principles of law which are the subject matter of jurisprudence, and their scientific study is the exact purpose of jurisprudence. Professor Stone described it as lawyers' extraversions, and it means how the lawyers define law and the legal concepts associated in their profession, and how they interpret every legal concept in the manner of their application and their introduction in the legal and social context. That is the meaning of jurisprudence. And Professor Gray or Justice Gray defined jurisprudence as a body of rules as interpreted by judges in court of law. So he emphasized on the realistic approach to study jurisprudence. To him, it is those rules or principles which are interpreted by the judges in court of law in various judgments or decisions. That is the study of jurisprudence, and that is law. So, to Professor Gray, it is man-made or judge-made law. Professor Holmes or Justice Holmes described law as a science of social control of human conduct and behavior. As a left-wing functional jurist and a former justice of this USA Federal Supreme Court, he defined it as a science of social control of human conduct and behavior, and that human conduct and behavior in the way that it is an investigation of an abstract, general, and theoretical nature and principles of law to achieve a general synthesis, evaluation, and improvement of legal concepts in a logical and rational manner. So, according to Justice Holmes, this type of investigation or evaluation or improvement of those legal concepts could only be made by the lawyers and judges in court of law while deciding a relevant case and while delivering the relating judgment or decision, and that is how Justice Holmes defined it, that it is a science of social control of human conduct and behavior.